Ethical Perspectives on the News is produced by the Interreligious Council of Lynn County, which is solely responsible for its content. The views and opinions expressed on this program do not necessarily reflect those of the staff and management of KCRG TV9.
Good morning and welcome to Ethical Perspectives on the News. My name is Scott Samuelson and I'm a professor of philosophy at Kirkwood Community College on the Iowa City campus. Recently, Governor Reynolds signed into law one of the country's most restrictive pieces of abortion legislation. The so-called heartbeat law bans abortions when a heartbeat can be detected, usually around 6 weeks into the pregnancy. It makes some exceptions in the cases of rape, incest, or medical emergency. The law is being challenged in court. Opponents argue that the heartbeat legislation is unconstitutional. Even supporters of the law recognize the tension between the new law and Roe v. Wade, but hope that a legal challenge might lead to overturning the famous 1973 Supreme Court decision about abortion. Either way, the law brings up some of the hardest legal, moral, and metaphysical questions for our country to agree on. When does life begin? How much freedom does a pregnant woman have over her body? What kind of laws should we have regarding abortion? What is abortion's moral status? We have a good panel on today to discuss this issue. To my left is Ginny Ryan, a reproductive endocrinologist at the University of Iowa. Ginny, thanks so much for being on.
It's a pleasure.
And at the end, Todd Pettis, a professor at the University of Iowa Law School. Todd, thank you for being on.
I'm happy to be here, Scott.
Well, Todd, maybe we can start with you. What exactly does this bill prohibit, and does it make most abortions effectively illegal?
Well, you described it well. Heartbeat is the threshold. After that, abortion is greatly restricted, almost always not permitted. There are very narrow exceptions for medical emergencies, which are the life of the woman, severe, or I think the statute says substantial, irreversible damage to a major bodily function, raped if they're reported within a certain time frame, incest if they're reported within a certain time frame. Other than that, if a heartbeat has been detected, abortion would not be permitted under the statute.
Yeah. Well, so Ginny, I mean, what does that mean, practically speaking, for what kind of abortions would be performed? Or, I mean, like I said, many people say this means basically by the time you find out you're pregnant, it's too late to have an abortion.
I think practically that's the case. I mean, especially if you're thinking about the unfortunate situation of rape, or you know, that has to be actually has to be reported, and in some situations that's just incredibly well, it's always incredibly onerous, but you know, in some of those situations that's not something that you should have to require a young person or a woman at all to report. And otherwise, for the 6 weeks, I mean, that's basically about 10 days to 2 weeks after, even though you could have a positive pregnancy test. And for women who don't have regular cycles, or they may not certainly even know they're pregnant, so practically it's banning it completely.
And what other, I mean, effects do you see this bill having if it is really enforced and becomes the, you know, effective law of the land, right, assuming the challenges are unsuccessful? I mean, so okay, most abortions aren't going to happen. What else would happen, just speaking as a medical professional?
Well, I'm concerned, as you know, and I wear a number of hats, and I'm concerned about the impact that it's going to have on the state of Iowa and training the next generation of providers, obstetrician gynecologists in the state of Iowa. I'm an educator and fellowship director, and this has been published, you know, in the local newspapers about how if the University of Iowa can't provide training in abortions, then that's going to be a problem in recruiting residents. We could lose certification for that. We already have very limited numbers of providers in the state of Iowa. It's one of the sort of lowest access states for obstetrician gynecologists for availability and access. So if we're going to affect that, lose our accreditation, that also impacts our subspecialty training programs, which are, you know, again, the only ones in the state of Iowa. So I have, you know, issues with that. That's a very serious concern, I think, for women's health across the state. I think there are also impacts on organ donation if we start to consider what changing the idea of, you know, life and brain death versus, you know, cessation of cardiac activity. That could impact the majority of organs are donated after brain death as opposed to cardiac death, for example. As a reproductive endocrinologist and infertility provider, I also have concerns about this moving towards the issue of life beginning at conception. Some people have tried to, propose that argument and legislatively, and we have big concerns about that as really affecting in a big way how we practice our infertility care. It would change our standard of care, our ability to practice standard of care.
Yeah, and one more thing I want to ask you before I get to Todd and this constitutionality of this. But I mean, a lot of people worry about, women who would still insist on getting an abortion even though it was no longer effectively allowed. I mean, what kind of concern do we have there? Is that something?
I think that's the most basic concern. I mean, I both personally and professionally, I feel like this is just overreaching. I think this is something that's a privacy issue that is between a woman and her physician, and based on her own values and her own medical and family, background. And so I think, history has proven this time and time again across the world that women will seek to get abortions, and if they're not legal, then they become unsafe, and it becomes a real issue. We know that, for example, in the rest of the world, that infertility, the biggest cause of infertility is from infection after illegal abortion. It's not an issue in the United States right now because of the legality of it, but it's certain that tide could turn, so women's fertility and lives could be at stake if this is not accessible.
Well, I want to come back to and unpack some of the moral things that are embedded in what you're saying, but let's just deal with the constitutionality of this for a second here, Todd. I mean, is this constitutional? Does this violate Roe v. Wade? What other kinds of frameworks do we need to be considering here as we think through the ultimate constitutionality and legality of this?
Okay, so let me just try to briefly describe what the Supreme Court says now about abortion rights, because once I describe it, if you don't already know, you'll see that as the Supreme Court interprets abortion rights now, there's no question that the statute is unconstitutional and it will never be actually enforced in the state. The only way the statute will be enforced is if the Supreme Court takes this occasion or another occasion in another state involving a similar statute and changes the framework. So here's the framework.
Okay.
And we've had two of them, Roe versus Wade, and then Roe was actually partly overturned in a case called Planned Parenthood versus Casey. Roe very famously set up a trimester framework, and the way that worked is that during the first 3 months or so of pregnancy, a state was not allowed to regulate abortion at all other than to ensure that the people performing them were qualified to perform them. And then in the second trimester, a state was allowed to intervene, but not to protect the life of the fetus, but rather to place restrictions that are aimed at securing the health of the woman. At the end of the second trimester, which is about at the point of viability, especially science at that time, after that, a state was allowed to intervene for the sake of preserving the life of the fetus, unless the life or health of the woman was at stake. That's 1973. In 1992, so about 20 years later, in a case called Planned Parenthood versus Casey, the Supreme Court looked at the first part of that, especially the first trimester and the second trimester, and said that it undervalued fetal life. And so the court moved the framework a bit, fairly substantially, in a pro-life direction. And they did so in this way. They said, we're not going to talk in terms of 3 trimesters anymore. There's really one marker point that matters, and that's the point of viability. After viability, the law of Roe stays the same. After viability, a state can ban abortions entirely unless the life or health of the woman is at stake, with some question about what kind of a health risk is sufficient. Prior to viability is where Casey really overruled Roe and put in what we have now. And there the rule is that prior to viability, a state cannot impose a substantial obstacle. They say you can't impose an undue burden, and the way we define an undue burden is a law that's been put in place in order to put a substantial obstacle in the path of the woman who wants to terminate that pre-viability pregnancy. Well, if you look at something like the fetal heartbeat bill, which says as early as 6 weeks or so, abortion is just simply not permitted unless it's an extraordinary case, in one of the ways that we described at the outset. That's clearly a substantial obstacle. That's not a point of legal controversy. Everyone understands that. We've had we're sitting here in Iowa, we're in what we call the 8th Circuit Court of Appeals. The country's divided up in these different numbered appellate courts that are very prestigious, important, powerful courts. They sit just below the United States Supreme Court. The Eighth Circuit has had 2 fetal heartbeat cases in the last few years involving North Dakota, and I think the other one was Arkansas, though I'm not 100% sure about that. And in both cases, they sit in panels of 3. There are 3 judges. Same judges in both cases. They were all George W. Bush appointees. They made it very clear in their opinion that they did not like this framework that I've just described, and that if it were up to them, they would write a very different framework. And under the different framework they would write, perhaps these fetal heartbeat bills would be upheld. But the court said in both these cases, we have no choice but to strike these down as unconstitutional. It's up to the Supreme Court to decide whether to change things. In both those cases, the states went to the Supreme Court and said, will you take this case? Which is how it works in this country. The Supreme Court doesn't have to take any of these cases. They decide. And in both cases, the United States Supreme Court said no. So this lawsuit that's been filed now recently by the ACLU and Planned Parenthood, their first order of business will be to get a temporary injunction blocking enforcement of the law. They will get it. The law will not be put into force. We'll then go through the litigation at the district court level and the Court of Appeals level. At those levels, the law will be declared unconstitutional, and everyone knows that. It's all about building the record and jumping through the hoops necessary to then say to the Supreme Court, what about now? Do you want to take this case? And if the Supreme Court says no, then it's done, and the statute will be something of a focus of a lot of political conversation and conversation like the one we're having here and now, but it won't actually be made reality. If it is made reality, it's going to make international news because it'll be the case where the United States Supreme Court shifts course.
And has the court changed in any significant way such that they might take the case now rather than...
The only change we've made since the 2 times recently where they said no was Justice Scalia passed away. Justice Gorsuch is now there. It takes a vote of 4, so we have a Supreme Court of 9, a majority of course is 5. You don't have to have 5 to put a case on the court's calendar, but you do have to have 4. And so far there have not been 4 justices willing to take the case, and that could be for any number of reasons. Thinking that we ought to wait a year or 2, we ought to wait for personnel changes. I'm happy with the law as it is now. It could be any number of reasons. And if they do take the case, there's no guarantee, far from a guarantee, that they are going to make a significant change. But we don't know until we get to that point.
And I suppose it's always possible too that a judge would, need to be replaced in the near future, in which case that could potentially shift.
Justice Kennedy, all eyes are this time of year on Justice Kennedy and what he's doing. When I described Planned Parenthood versus Casey, that critical opinion was co-written by a group of 3 justices, 2 of whom are no longer on the court, Justice O'Connor and Justice Souter, but Justice Kennedy was one of those. So he is the author of the current standard. And he's moved a bit on different things. He's sometimes been with the right, sometimes been with the left on these cases since then.
Well, I guess I have one more question for you before we get to kind of just some of the moral issues in all of this, but about the constitutionality. I mean, so on the one hand we have this question of does the current law, fit with Roe v. Wade and later with Casey, and the answer is no, it does not. But I suppose some people would say, but maybe Roe and Casey, or especially Roe, has been misdecided, and we've been living under an unconstitutional interpretation of the Constitution for the past 40 years. And that, in fact, Roe is unconstitutional, and the Supreme Court should recognize that. So, I mean, I'm interested in this deeper question of, what is the constitutionality of this issue? I mean, I guess that's a big question, but that, when push comes to shove here, was Roe correctly decided or not?
In our system, that is up to the Supreme Court to tell us. The Supreme Court says the Constitution means what we say that it means. And so there's no kind of platform that we can step out of the system and stand on, and from that vantage point make some kind of objective declaration about whether this case is rightly decided or wrongly decided. Roe is a tough case. There's parts of it that are pretty susceptible to challenge. There's ways in which I think if that court today could go back and decide the case again, I think they'd say it a little differently. Let me just say one other little wild card, and that is, as we speak, The Iowa Supreme Court has in front of it a case concerning the 72-hour waiting period, which is a requirement that was put in a year ago and which has been put on hold. And that case is asking whether the Iowa Constitution provides even more protection than what I just described Casey is providing. And it's possible that the Iowa Supreme Court, just possible, I have no inside information, but it's possible the Iowa Supreme Court will say that the Iowa Constitution gives Iowa women even more protection. And if that's the case, it won't matter at all what the United States Supreme Court says or which justices change, because in Iowa, abortion rights will be even higher, which is true in about a dozen states.
That's interesting. Okay, well, let's come back to some of the issues that were embedded in some of the things you were saying, Ginny, particularly some of the moral issues. I take it that there are going to be some people who are going to say, many people are going to say, look, you know, it is our job to protect innocent life. And you have a heart beating inside someone. This person has done nothing wrong. And how can we take that person's life? That life begins with that heart beating. We have a kind of sense of that, and it's a grave wrong, and that particularly doctors perhaps should not be involved in the taking of this kind of life. How do you respond to something like that?
Well, I think the key points are in some of the words that you use. I think that just the idea of when does life begin? I think you have to think about independent life, the life of this fetus. Well, at the point of first heartbeat, it's not even actually a fetus. We're talking about an embryo, actually. So it's really a few cells that are independently beating in an embryo that, as per sort of how Roe was decided, is not life without the mother.
Right.
The gestating woman. And so the idea of protecting that life, it's not in and of itself a life, or, an innocent life, or it's a continuum of from the time that egg and sperm come together, and have this potential to create, but there are many steps along the way that have to go right, including the incredibly important step of the gestating woman. And so I think in any way separating those things is problematic.
Right. But I mean, and it does seem to me that the borderline between life and death is fuzzy at some level. As you say, I mean, we can talk about the sperm and the egg meeting and then a set of things unfolding. And I feel uncomfortable myself with ever saying, oh, now it's there. But I take it, though, that you could make a kind of you could sort of have a conservative position about this and say, well, if we don't quite know the borderline between life and death, shouldn't we err on the side of caution? Shouldn't we be more inclined to respect the kind of life unfolding? And even if we're not quite sure exactly where it begins, shouldn't we be always trying to protect that unfolding life, even if it's perhaps not a full-blown human being as yet?
I definitely agree. I mean, there's nothing like working in the world of infertility to really develop a healthy respect for this potential and the respect for the incredible potential of these two cells that come together, and it's amazing and certainly deserves respect. But you have to ask yourself at whose expense. And I think to really respect the children and family, and also means to respect what public health tells us about community health, which and women's health, and really the healthiest families and the healthiest communities are based on when women have the ability to control their fertility. And so we have to go all the way back to how about we talk about giving women the tools that they need to be able to build those healthy families, including access to contraception and preventive care, and all of these things that seem to be taken away bit by bit from women, along with rights to abortion. It seems to be for some reason packaged along with also taking away their access to contraception, also taking away their access to good preventive care. It seems to be more an attack on women's rights when these things happen, rather than really about kind of looking at the data. What does the evidence tell us for how we have the best healthy families? Right.
Well, and this is a question maybe to either one of you, or I'm just interested in this idea of viability as being one kind of important line that you say, something like, you know, Casey has drawn for us. But I guess in my mind, I keep thinking that viability is itself a very variable line to draw, that as medical science becomes increasingly powerful, I mean, viability could mean at conception, right? That you could have something viable. I mean, I'm not saying that that's quite right, but you get what I'm saying, that it seems like viability used to mean a very late, you know, term, late in the overall pregnancy, and maybe it still mostly does, but it seems like we've pushed that back further and further and further. If we do draw the line at viability, does that mean that it could potentially be that the state would have the right to keep alive a child, you know, outside of the womb? The
law is on kind of a moving walkway or a moving platform right now, and that's one of the criticisms of Casey, is that it's not necessarily a standard that is set to endure for another century or something, because science is changing, and we probably don't have time to get into the specifics, but that's one of the reasons why Casey changed the Roe framework, is that there were different moving parts, and pregnancy, or rather abortion, was becoming safer later and later into pregnancy at the same time that viability was moving earlier and earlier, and those two things played central roles in the development of the trimester framework in Roe. And so one of the things that they were doing in Casey was trying to reduce the number of moving parts. So they took out the part about at what point does abortion become safer and safer, and they just focused on viability. But that itself, as you say, is moving, and it moves earlier, and it will move earlier and earlier and earlier. And it, depending on how early it goes, we might or might not find it a satisfactory marking point, if we find it a satisfactory marking point today. Right.
I mean, I guess I'm interested in, you know, so if we go down the road of saying we got to think about when life begins and talk about when do sort of rights appear, or when does humanity appear such that it deserves full moral respect, I mean, there's all sorts of ways of drawing the line. One is at conception, where we would say this is where the ultimate destiny is been set all of a sudden. The genetic destiny is there, and everything will unfold. Or we could say at the heartbeat, you know, we've often thought of, like, you know, if someone passes out and we're nervous about whether they're alive or dead, we feel for the heartbeat. We feel as if that's the crucial thing. Or then there's the idea of, well, maybe brain development, which would come much later, or viability, which, you know, like I said, it could, depending on what we have going. Or it could be once it's finally out, you know, and born. Or
even some people would argue when somebody has moral agency, which is
which would be even further down the road.
Right, teenage years or something. So.
Well, right, or there have been extreme philosophers who have said, yeah, that infanticide would be okay because, you know, the infant is you know, not fully cognizant of what's going on.
Right.
So I suppose, I mean, there's any number of ways of drawing that line there. Is it an important question as we approach this debate to answer that? Do we need to have some sense of where that line needs to be drawn to answer this legally or morally? Or do we need a different approach? And if we do need to answer that question, how should we answer it? What is a fair answer to that question?
Well, that's the big question society's been debating for a long time, and I'm sitting in the law chair, which is kind of the easy chair, because in the sense that
you can say, let the Supreme Court decide.
Well, this discipline would say to scientists and to ethicists and philosophers like you know, what's the input and so forth. But law has a limited number of sources available to it, which is one of the critiques of Roe. Is, you know, you've got to find all of this in the text of the Constitution or in our nation's traditions. You know, at the time Roe was decided, all states placed pretty significant restraints on abortion. The Texas law was not an outlier. There are about 30 states or so that had these very strong laws, including in Iowa, banning abortion with either no exceptions or just a life exception for the woman. So law's tools are reduced. So, you know, when you think about it from the science point of view or the philosopher, you don't have those constraints.
Right.
And so I think of it as...
But isn't one of the big arguments against Roe essentially something along the lines of what you've just said, namely that this is such a difficult issue? You know, why not let states decide the issue? Let some people have strict abortion laws because they think one thing, and let other people have more lenient laws because they think another thing.
I think and there's the counter argument too, that because there's different ways of defining these things, why not let individual women decide for themselves what the proper marker is? So I think what the law is interested in is setting the marker at which society will no longer tolerate choices to terminate. Prior to that marker, some may think that it is just as wrong as it would be after that marker to terminate a pregnancy. Others might think it's totally morally inconsequential, but there's going to be a zone within which women can make their own choices. And you know, the fetal heartbeat bill, the occasion for our conversation now, that really pushes that zone down. I mean, Ginny was saying earlier, many women will have just discovered that they're pregnant. So that's a very small window for people to make their own decisions. But in any event, from whatever sources the law draws when deciding what the critical point is, that's I think what the law is trying to do, is decide prior to now, women can make up their own mind. After now, society finds it unacceptable, in the same way that society would find it unacceptable to kill one's child after he or she has been born. I mean, I'm interested in, you know, that the law itself makes exceptions for rape and for incest. I mean, and I wonder if there's not a tension a little bit in there, in that if you know, it shouldn't really matter whether I am the product of a rape or not. It seems like all my rights should accrue to me one way or the other. And I wonder if that doesn't open up the door that perhaps this issue is a little more complex than just where life begins, that there really is a kind of a difficult moral gray area here that becomes very hard to legislate effectively, that we all have perhaps slightly different ways of sorting out that moral gray area. Most of us are uncomfortable with some abortions. Most of us do feel like some abortions are wrong and maybe even you know, deeply wrong. But at the same time, many of us also have a sense of, well, but I can kind of understand it in a lot of cases as well. And so if that is true, that there is a lot of gray area, what kind of laws should we have that should we just say, well, let women choose whatever? But aren't there times when we might say that that's going too far?
Well, I mean, my bias would be that this is not the place for the law to be stepping in really very much at all, besides some very obvious extreme cases, I would say, because, you know, I don't think you can ever forget the profound responsibility challenge. I mean, I think about when they say, well, there's an exception for the life of the woman. Every pregnancy is life-threatening. It is much safer to not be pregnant than to be pregnant. And we can't always predict when a woman is going to lose her life or have any significant medical issues from this. So, you know, I think that the idea that we can legislate what happens to somebody after one sex act has resulted in the pregnancy, I think is just pragmatically and fundamentally, you know, I don't think it's the place for the law, honestly. But you know, that's my bias, but that's, I think, where I would stand on that.
Well, I mean, this is the kind of issue that we could keep going and going, but I'm afraid we're out of time. So I'd really like to thank both of you for a lively discussion. As hard as this issue is to discuss, I hope that we insist as a society on doing so. You know, maybe there's more agreement than we suspect, but even if not, I mean, these are fundamental issues about who we are as a people. So anyway, I hope the conversation we've begun here today is one that you carry on in your homes and communities. So thank you very much, and we'll see you next time on Ethical Perspectives on the News.